Can I first of all then sort of introduce a few people that you can see presenters on the screen today. And our key presenter from Drummond Laurie is Gillian Wayne. Gillian works for our accountants, Drummond Laurie, and she is an accountant practitioner with over 15 years professional experience. Jennifer's worked with Drummond Laurie since 2013, working with many varied clients, including contractors. And again, since the inception of IR35, Gillian has worked within the legislation and advising and supporting clients. So welcome, Gillian. Our next presenter, well, again, panelist, and Greg will answer questions, is Greg Brown. Greg Brown is, again, a director from Drummond Laurie, and Greg will, again, I think Greg will, his duty today will be to assist any difficult questions and assist Gillian when we get to the Q&A session. And then we have, you'll see on the screen, Ian Honeyman, who is SBS Commercial Director, and Jennifer Ray, who is SBF's Financial Controller today. So today's session, I'm just going to end the poll here. So today's session, the key topics, we will first of all cover IR35 background, why the introduction of IR35, and again, you know, it is not new, as most of us will be aware. IR35 was first introduced back in 2000, so it's been around for sort of 20 years, and the preliminary stage of that. So Gillian will take us through that in the history. She'll then go on to talk about the mechanics of how does it work and what does the new part of the legislation, what does that mean to you? And then talk about the issues associated with the new process. I'll then take you through, hopefully briefly, albeit there's lots of slides, and this is where employment status, I believe, is very aligned to IR35. And I think if we can understand employment status and how we engage with workers in our businesses, I think hopefully that will give us a greater understanding. And then at the very last, the last minutes, we'll have a question and answer session. So without more ado, I'm going to pass you over to Gillian Wayne. Welcome, Gillian.
Thanks, Vaughan. Thanks for the introduction. So morning, everyone. So I'm here today, as Vaughan has said, to try and talk you through the changes that are happening with the IR35 legislation. So if we want to look at the first slide, Vaughan, so if we just go, but we'll start with a bit of a background. Most of you guys will be well aware of the IR35 legislation. As Vaughan said, you know, it was introduced back in April 2000. And when it came into play back then, it was really aimed at contractors who were trading through their own personal service companies. So when I'm talking about a personal service company here, I'm meaning a sort of one director or a family-owned sort of business, where it's a husband and wife company, maybe, that type of idea. That's what they were aiming this legislation at. Now, why did they introduce this legislation back in 2000? Well, at the time, the government felt that there was a bit of a loophole there, a bit of a tax loophole. Contractors who were trading in this way through their personal service companies, and some of you guys will be aware it was very tax advantageous to trade this way. You could also potentially share your income with, another shareholder who wasn't necessarily fully involved in your business. So there were some quite beneficial tax breaks into doing it that way. These guys who were also trading through their personal service companies could get tax relief on things that a normal employee maybe couldn't otherwise have got. So maybe things like travel and subsistence costs, if you had to buy some equipment, things like that, they were getting tax breaks on it. And at the time, the government just felt that, contractors doing that type of work should be paying a similar level of tax and national insurance as an employee would. And that's why they introduced this legislation to try and clamp down on that. Now, who had the responsibility for ensuring compliance with the legislation? Back then, it was the ultimate responsibility of the contractor or the director of the personal service company to ensure that they complied with the legislation. They ultimately had to decide whether the scope of their engagement with the client or the end user was within the scope of IR35 or whether it was out with the scope of IR35. And really, as such, because they had the responsibility for taking this decision on it, they were on the hook if the revenue tapped on their doors to say, you know, you should have been treated as an employee here. They were on the hook for the tax and national insurance that had been under-declared from trading this way. Okay, so that's a kind of brief look at the sort of history of it. We'll move on to some of the changes that came into play. Now, I've been in practice for a good number of years now, and a lot of my portfolio is predominantly made up of contractors. And over my years in practice, I've never fully seen HMRC try and implement this legislation properly at this level. There has been a few sort of high profile cases in the press, mainly sort of presenters and you know, TV and radio presenters that have been pulled up for not complying with IR35. But at a sort of client-based level for me, I've never fully seen it try to be implemented. So in April 2017, what the government did was they started to feed some changes through to the public sector first. Now, it's important to note that the basic principles of IR35 haven't changed here. They're still the same. But what did change was who was responsible for implementing the rules and ensuring that compliance was met. So back in 2017, the government made changes in the public sector so that the client or the end user now became responsible for ensuring that the contractor was complying with the IR35 regulations. You know, ultimately they had to go through a process, because you can imagine that a lot of these businesses would have been using contractors at the time. That, you know, the advantage of using a contractor is you've got flexibility there over an employee. If you maybe have a one-off project and things that you need that wee bit expertise for, you've got the flexibility to bring them in. So they really had to look at their contractor base at this stage and say, right, who is genuinely self-employed here and who should be classed as an employee. And at this point, it's important to note as well that because the client or the end user is now responsible for making these decisions, the liability for any underpaid PAYE is ultimately now with the client or end user rather than the contractor of the PSC. There was quite a bit of criticism in the press at the time when this was rolled out in the public sector, because a lot of these organisations took a blanket approach to this, a no-risk approach if you like, and deemed all contractors to be within IR35. And the result of that was that they were either advised to come on payroll, so if they wanted to put them on the payroll, then that's what they did, or they moved them to trade through an umbrella company, and ultimately the umbrella company would have treated them as an employee and deducted tax and national insurance on them. That's something that the Revenue, you know, in particular criticised at the time, because they felt that these organisations should have been taking due care in assessing each individual contractor rather than just going for this blanket approach like they did. I guess I can see why the organisations went for the no risk blanket approach. However, it was criticised. Okay, want to move to the next slide one? So I guess once these changes rolled out in the public sector, it was only, you know, the Revenue kind of dipped our toe in the water a wee bit there, and it was only ever going to be a matter of time before the changes were then rolled through to the private sector. And the same thing is happening now. So these changes were originally meant to be implemented from 6th of April 2020 last year. However, due to COVID, like lots of things HMRC were going to implement last year, they delayed it for a year. Now, I don't think it's going to be delayed any further on this. I think we're now on the 11th of March. They still seem to be going full steam ahead with the changes coming into play in the private sector. So I can't see it being delayed any further. I think there was probably a lot of the companies in the private sector last year would have gained a bit of an advantage from the delay, to be honest, because I know from my experience, predominantly in the oil and gas industry, there was, you know, very few companies that were actually prepared to implement this at the time when the changes were meant to come in last year. A lot of the contractors that I deal with still didn't have status determinations at that time as to whether their client felt that they were trading within or out with IR35. So yeah, I can't see any further delays happening on this now. I think we're in it now, it's going to happen. So who's going to be impacted by the changes? So the public sector's already been dealt with, so we're looking at anyone trading in the private sector now. Anyone trading through their own PSC. So if you are one of those limited companies where you have maybe 1 or 2 directors, you know, it's classed as a personal service company, you guys are going to be impacted on this. It's important to note here actually that if you are trading as a sole trader or already trading through an umbrella company, nothing's going to change for you guys. It's purely just when you're trading through a personal service company. And anyone who's contracting with a medium or large company is going to be impacted by this. Now, I'll give you a kind of brief definition of a medium or large company, just so you're aware. It has to meet 2 or more of the following criteria. So the turnover of the company has to be more than 10.2 million. The assets of the company have to be more than 5.1 million, and employee numbers must be greater than 50. So if you're trading with 2 or more of those criteria, then you are classed as a medium or large company. And probably the easiest way to, you know, fully understand it is if your accounts are audited accounts, then you will be medium or large. If not, then you will be small, unless there's some sort of, you know, special exemption there. But, you know, 9 times out of 10, that's the way it will work. So ultimately what's going to happen here, any contractor trading through a PSC, the client or end user is now going to have to determine whether these guys are trading within the scope or out with the scope of the IR35 legislation. Now, if the client or end user deems that the contractors are trading within the scope of the IR35 legislation, they should be deducting tax and national insurance at source in line with how an employee would be treated. If they deem that they're trading out with the legislation, their fee will continue to be paid gross, maybe subject to CIS tax deductions, but they won't be treated as an employee. It would be and suffer sort of tax and national insurance on it, as they would. All right, so that's the big change there. Next slide, please, Laura. So how is a decision about all this going to be made? You know, you can imagine for some of these companies who are using contractors on a daily basis, they've got a big task on their hands to get this implemented. And it's going to go back to the legislation, the badges of trade legislation that's been well established by the Revenue for, you know, for a long time, in determining whether an individual is an employee or whether they are a genuinely self-employed individual with a company. Now, things that are going to be looked at when I talk about badges of trade, we're going to look at who has control. So in the day-to-day job, the contractor should have full control over what they are doing. You know, they should be able to set their own working patterns. They approach the work the way they want to approach the work. They're not answerable to anyone other than the fact that, you know, the client will have deadlines to be met, but really they're left to their own devices on a daily basis. Who's providing the equipment for the contractor? So it should be written into the contract that the contractor is going to provide their own equipment. If I turn up on site one day and I've got all my equipment provided for me, then that's a massive red flag that I'm an employee rather than a self-employed individual. The contractor has to remain totally separate from the client's business, so they don't want to be getting involved in HR matters. They don't want to be managing staff. And they certainly don't want to be involved in any form of recruitment. Okay, they have to be there just really for their specialist skills and expertise in that one-off project that they're doing. Exclusivity, you'll hear this term as well. So if a company or a client or end user is using the same contractor over and over again for a long period of time, again, that's another red flag that they're likely to be deemed as an employee-employer relationship rather than someone who's self-employed and who moves around different businesses. Risk and reward. So if your contractor messes up on a job, for example, are you going to pay them to put the project right, or are they going to have to suffer the costs themselves? You know, that's what being self-employed is all about, taking a bit of a risk and getting a reward for it. As an employee, you don't have to do that. If you mess up, you're still going to get paid your salary regardless. So, you know, just watch out for these sort of red flags here. Probably one of the, you know, the bigger ones when it comes to contracting and one that you'll probably all be aware of is the substitution clause. Now, it's very common, and I've seen it over the years in a lot of contracts, that there is a substitution clause as standard in there. So if you can't turn up to site one day, you can substitute, you for someone else of the same skills, same experience, and the client or end user is going to accept it. Now, what I would say about that is, with all this legislation, the revenue are sort of now digging behind the words of the contract and looking at what happens in practical terms. You might have a substitution clause in your contract, but have you ever accepted a substitute if your contractor can't come into site? And that's what the revenue are going to look at. And I think, even though the clause is there, it would be a red flag if you can't turn around and say, well, actually, my contractor regularly substitutes for someone else, because it will just be deemed as a disguised employee relationship there. So that's the basics of what the client and the end user has to look at when assessing whether the contractor is genuinely self-employed. Okay. Now, in coming to the conclusion, what might happen is the client might engage a third party to conduct a review of all their contractors. I've seen this with some of the bigger companies, in the oil and gas, and certainly in the banking sector, they were quite big on this. Getting someone, totally independent. And then what happens in that instance is they would send out a whole load of questionnaires to your contractors, really digging about on these points, in the badges of trade, and not just asking are the clauses in the contract, but what's happened in the past. Can you give examples of when you've substituted, or, can you give examples of when, you've had to put something right, or you've not been on training courses, you've had to pay for your own. So that's been quite common. So you might be getting some, any contractors here might be getting some questionnaires out. The other thing that the client or the end user can do, HMRC has an online CEST tool, they call it. So this is checking employment status for tax. Now, anyone can go on and use this, whether you're the company or the contractor. You can go on and put your information into this CEST tool. It's a series of questions. It's completely anonymous. You don't have to put in your tax reference number. I don't even think there's an option to put it in, so you're not identified. But by answering the questions at the end of it, it will come up with a conclusion for you as to whether you're within or out with the scope of IR35 legislation. It's only as good as the information you're putting in. So you have to be accurate with what you're putting into the tool. I would imagine if you do get an inquiry in the future, you've got this CEST tool, you've got the, why you deemed or why you made the decision that you did for a particular contractor. They will review the information that you're putting in, and if there are inaccuracies there and it's come out with a wrong decision based on that, it's not going to be upheld. So you need to be careful with what information you're putting into that. So ultimately, once all this work's been done in the background, the result is going to be a status determination that the contractor will receive, and the companies need to send out to their contractors. It'll give them a bit of chat as to how the company has come about the decision that they've made, and it will conclude as to whether they believe that they're trading within or out with the rules of IR35. All right, so next slide please, Lauren. Okay, so what should I do next? So there's probably 3 questions that you need to be asking yourself here. Am I in the private sector? Do I trade through my own PSC? So am I one of these guys who's got my own limited company? Again, sole traders, it's not going to apply to you. Am I contracting for, or am I a medium or large company here? And if the answer to the above is yes, then you need to be aware of how the rules are going to impact you going forward. And ultimately you need to make sure that this status determination is coming your way, or that you are getting these out to your contractors. Just one important point there on the am I contracting for, or am I a medium or large company? If you're working for a small company or contracting with a small company, or if you are the small company, then IR35 legislation is still there, and the rules still need to be considered. However, it's important to note that the liability falls back to the contractor. Any decisions made on the status of the contractor need to be with the contractor and not with the client or end user if you're in that position where you're a small company. And likewise, any risk, any liability for unpaid tax or national insurance is going to fall back to the contractor rather than be with the client or the end user. Now, that's the rules at the minute, and that's what's going to come into play from the 6th of April. However, you can see the changes have gradually went from them not doing too much about IR35 to implementing it in the public sector, to then putting it into the private sector. I wouldn't imagine it's going to be too long before, small companies are caught up in this net as well. It's just probably going to be a matter of time before that happens. The Revenue haven't said anything official about that, but I would guess that, that's the way it is going to go. Okay. Last slide, please, Vaughan. So just really to summarise, from each of your positions, what you have to do next. If you are a contractor listening to this, you need to ensure that you're receiving your status determination soon. We're now on the 11th of March. It's not going to be long until this is coming into play. And for any contractors out there who may now fall within the IR35 legislation, it's obviously going to impact what you're taking away in your hand every month. So it's, it's important that you know. If you're the medium or large company, you need to ensure that you're accurately assessing the status of your subcontractors and providing each of them with individual status determinations. Now, again, I just want to highlight the fact that it should be an accurate assessment. It shouldn't just be a blanket approach like what has been sort of seen in the past. So, seek advice on it if that's what you need to do. Right of appeal, so if the contractor is given their status determination and they're not happy with the outcome of it, they do have a right of appeal. The appeal goes to the company that they're contracting with, the client or the end user. It doesn't go anywhere near HMRC, and once they receive the appeal, they have 45 days to respond to the contractor. Now, my thoughts on the appeal process would be that if the medium or large company assess you as falling within the scope of IR35, it's going to be very difficult to get them to move on that because ultimately they're on the hook. So if they think there's any risk there that you could be seen to be an employee, then they, I would imagine, are going to, go on the side of caution rather than taking any risk with this, particularly for companies who are using contractors regularly. They maybe have a more contractor base than what they do employee base. And that's what it's going to come down to, as I guess, a level of risk that they're happy to accept. Right.
Gillian, thank you very much for your presentation. Again, I'm sure everyone that was incredibly informative, and I think probably even more thought-provoking. Where are you going to go? What are the implications? Before, even now, if you want to go into the Q&A session and start writing those questions down for Gillian thereafter. So again, we can talk about that. Again, probably for my own selfish perspective, in a way, I'm quite delighted because this is showing a huge synergy, this part of IR35 and employment legislation, which is obviously from my background and my level of professionalism. So again, if we talk about then employment status, so I'm going to move on swiftly. So why assess employment status? And the first one, and probably the most obvious one that we've seen in the press lately, is the increased number of claims challenging status. And the one that we've probably all seen in the press in the last couple of weeks is the Uber case. And for those of you that aren't aware, Uber drivers were arguing that they were not self-employed. They were in fact workers or employees of Uber, and as such they should have enjoyed further benefits than they did. At the end of the day, they won their case and they are now classified as workers, albeit Uber is saying they're now going to change the business model. But a very, very interesting case. You might want to have a look at when you're looking at reviewing your business. And I would argue, I mean, we advise, and I've got Paul Mitchell on the phone, who's on our head of HR, Employment Affairs for Scottish Building, and Paul, I know, deals with many cases such as this, and we both do in a way with regards to the status of employees or workers with our members' business. The other point I put here is you only normally get a problem if there's a breakdown of communication between the both parties. And again, we're probably seeing it more than ever now due to the fact of COVID, that businesses are looking to be perhaps more flexible. They're looking perhaps to lay people off or not engage with certain workers or self-employed people. And this is where the problem comes around. I do believe, again, just to reiterate, that the industry does have significant challenges with regards to workers' status. And again, over the last 2 decades, and I think this is due to the fact that we have remodeled our businesses. We've gone from a risk acceptance culture to a risk averse strategy, whereby we want to limit, especially with the bigger businesses, the risk that we've potentially got moving down the tracks, especially when work is not guaranteed. And again, the last point that I put here is the potential ramifications, which we just heard from Gillian with regard to IR35. And some of the points that I'm going to cover will probably just reiterate or reaffirm what Gillian said earlier on. But first of all, I want to take you through these next 2 slides very, very quickly. And I wrote these some years ago. We're really trying to explain in graphical format where we are as businesses. And the most important thing is the traditional business model is whereby we employ directly the majority of our staff. So the core, the inner sanction or sector of our business is pretty big. Yeah. And what we then do is the first peripheral group is whereby we contract specific work to go out for specific trades. And that could be plumbing, it could be electrical if we don't do those in-house. And then again, the second peripheral group is the part-time. So that is really the traditional model. Within the last 20 years, we've moved on significantly to this next slide. Yeah, and you can see quite hopefully, obviously, and I think this really happened to me within construction between 2008 and 2012, where businesses wanted to protect themselves, but understandably, and therefore outsourced quite a few functions within their business. And we did witness, our member companies saying, right, I'm not going to do scaffolding anymore. So actually the squads of scaffolders, will you go and work and create a limited company and then work for us as a subcontractor? Yeah. Bricklayers, exactly the same. So what happened as a result of that is these people shifted from direct employment to effectively subcontractors. And what I want you to do now is perhaps go and look at where you are and effectively identify whether you come in line with a test that we're now going to go through. So again, moving very quickly, we have 3 groups of people. We have the employees, who are employees, obviously enjoy the full protection of employment law, workers, who do have certain rights such as holiday pay, national minimum wage, etc. And then we have the self-employed, which we've been talking about. And these are people that are, and I'm going to say inverted brackets, genuine self-employed, who are considered commercial contractors, and they're actually not protected by the same way in employment law as the other groups that the employees and the workers are. However, if the self-employed contractor is required to perform their work personally, they might have protection under the Equality Act, as any customer, any visitor will have within your business anyway. So that's the first slide. So an employee is someone who works under a contract of employment, whose duties are controlled by the employer, and usually cannot substitute another person to do their work. And as Gillian said, she talked a wee bit about substitution earlier on, and I want to go into that in a wee while. In addition, has employment rights. So they have maternity, adoption and paternity leave, the right not to be unfairly dismissed, the statutory right to redundancy, and all the rights that are given to workers that we're now going to go into. So workers, I wish I'd taken the animation off, so I'm just going to click through here Again, workers, a broader category than employees. They normally exclude those who are self-employed. Really, it's someone who works for an employer, whether under a contract to do or to perform personally any work or services. And that could be, for example, price work. You're bringing someone in for a fixed period of time to do price work. Yeah. These workers are entitled to core employment rights and protections. Again, you know, probably most notably holiday and national minimum wage. Yeah. So therefore, if you have a worker that's working for you, they're not an employee, they will be entitled to those minimum benefits there. Yeah. And the following groups of people are likely to be employed. They're not exhaustive, but they're likely to be workers but not employees. Most agency workers, short-term casual workers, or we're hearing now in the gig economy, the zero-hour worker. Yeah. And that could be a zero-hour worker that's got a mutuality of obligation to attend work, or it could be an employee who's actually gained. So therefore, there's a differential term there. But again, normally short-term casual workers, and then some freelancers undertaking intermittent work or projects for you. Yeah, so that could be someone who you've decided just to come in for a certain period of time, just to do a little bit of work, but they're not going to be brought into the business as an employee. So workers' rights. Again, national minimum wage, as we've just said, they are obviously, you have to comply with workers to the working time regulations, including rest breaks, paid holiday, and limits on night work. Protection against unlawful deduction from wages, so they do have protection under that. To maternity, paternity, and adoption pay. Protection against less favourable treatment due to being part-time. A lot of us understand the part-time workers regulations. Entitled to statutory sick pay. Protection against less favourable treatment if they make a disclosure under the Whistleblowing Act, for example. And again, not to be discriminated against unlawfully. And moving then swiftly to the definition of self-employed. These are effectively the indicators. There is no contract of employment in situ, but be careful of that. There's a famous case called the Auto Cleanse case, whereby they were deemed by the employer, because they had a contract that said I'm self-employed, a contract for services, not of service, and it was overruled and decided that it was a European ECJ case, European Court of Justice case, and they were then deemed to be effectively employees and workers, not self-employed. Likely to be contract to provide services over a certain period of time for a fee, be in business, and we'll cover this one in a wee bit, in their own right, pay their own tax and national insurance contributions, and a contractor or subcontractor registered under the CIS scheme. However, my only caveat here, and I think this is really important, there are lots of self-employed workers that tick the box under the CIS scheme, but if you drill down, exactly what Gillian was saying earlier on, in practice, you would potentially argue that they could be employees. So just be aware of that. Exactly what Gillian said earlier on. What we need to drill down is not what's said what's not been defined through a computer program, as in an HMRC portal, but that portal will already churn out what you put in. Yeah. So in the majority, you can make that churn out what you like. But if you end up in an employment tribunal, they will then dig beneath that. So their employment rights, they don't have any. However, they do have the right to be not to be discriminated against. They're entitled, as under the Health and Safety at Work regs, to a safe and healthy working environment. And self-employed women who have recently left their jobs may be entitled to maternity allowance. So be very aware of that. So how to work out employment status for employment rights? In tribunals will normally use either one or all four of the following tests. They use a control test, an integration test, a mutuality of obligation test, and an economic reality test. And when we go through each of these in a minute, you'll see that these tie in pretty tightly with how you would define IR35 as well, and it ties in within the legislation. So the first one we're going to have a look at is the control test. The extent to which the employee decides the employer decides what tasks the person will do and how they're done. So the control element, yeah? Is the employer or the contractor bringing in a subcontractor to do a specific work in line with a schedule, or are they controlling them a little bit too much? So does the individual have the final say in how their business is run? So this is the subcontractor. Can the individual choose whether to do the work themselves or send someone else? And that's where you get into the substitution test, exactly what Gillian was saying. And a typical example here is, I have a bricklayer and I'm bringing them in as a subcontractor to build a brick wall. Yeah. So if, for instance, they don't want to turn up one day, can they send their colleague in to do the work, and would you be happy with that? And not only does it say that in contractual terms, does that happen in practice? And I think that's really important to understand. And the last is, can they choose when and how they will work? And an argument that we face many a time here is, well, the site's only open between 7 in the morning and 5 o'clock in the evening. We'll have to determine that. However, that's absolutely fine. But when they're working, can they have a break when they want? You know, some days can they do less hours than your normal employees because that's what they want to do, as long as they work within the loose or the defined contractual parameters that you're setting them within the contract for services. And I think we need to have a look at that. The next one we'll have a look at is integration. This is the extent to which the individual is part of the organization. So if they need assistance, are they responsible for hiring other people and setting their terms of employment? So you've asked them to come in and undertake a specific duty, and that could be, again, first fixing a house. Yep, you've got a plot one, and they're coming in and they're first fixing. Are they responsible for bringing in other people to do the work? Or if they need a hand, if they need a labourer to assist them, do they have to bring in the labourer? If they need another joiner, do they bring in the other joiner to help them, or do you bring that other joiner in? And I think that's an important one, and I think this is one worth assessing within your own business context. Does that happen? Are they excluded from internal company matters such as corporate training and staff meetings? Within construction, you would expect them to attend toolbox talks. But if you're going to have a company cultural change meeting, you're going to have a company update meeting, are they invited to those or are they not? Yeah. So again, that's important to establish. In the majority, they won't be, but sometimes I've seen examples whereby the subcontractor goes through exactly the same level of communication and integration within the business that any employee would. There is no distinct difference. Are they exempt from having action taken against them using a company disciplinary procedure? And again, I've seen that, surprisingly, that I know we generally in construction use the warning, the amber and the red card, the football penalty, sort of the yellow card. You can tell I'm not a football supporter, a yellow card and a red card analogy. But is that used with these people? Because you'd argue if there is a subcontractor, if they weren't doing as they're told, you would actually write to them, or you'd give them one warning, and if they don't do what they're told, you wouldn't have them on site because they would be in breach of their contractual terms with you. You wouldn't follow a normal, natural employee-employer disciplinary or dispute resolution process. Again, are they excluded? And this is pretty obvious. Are they excluded from company benefits and pension schemes? So again, I've seen lots of self-employed people using and having the loan of company vehicles and the benefit of the company vehicles. That, to be honest, is quite strange. Yeah, because that could actually say that they're actually enjoying a perk or a benefit of that company. I think we've got to assess that. The next test, very quickly, is then the mutuality of obligation test. The extent to which the employer is required to offer the individual work and whether they're expected to do it. self-employed people, do you offer work only if and when it's available? Or is there examples of that self-employed person, even if you've got a limit of the work, you're still finding work for them to do? Yeah, that might be an indicator that they're in fact an employee or a worker and not a subcontractor. Can the individual decide when they will work, and can they turn down work when offered? Yeah, to me, this is really, really important as well, is actually establishing, again, going back to this control. If you offer them work and they don't do it, do you then engage them again, or do you try and discipline them? Again, these are all examples that I will argue that Paul and I deal with quite frequently. And again, the last one is, can you prove that this happens? Yeah. The last one that we're going to look into, again, before we conclude, and the questions, is the economic reality test. And I find this one quite a fascinating one. The extent to which they bear the financial risks. And if you can permit me, I will talk about this for a couple of minutes. Are they responsible for meeting the losses as well as taking the profits? And are they responsible for correcting unsatisfactory work at their own expense? Now, in the majority, because you as companies can buy the product or the material at far cheaper because you have a bigger ability to procure, you're not going to want your subcontractor to supply and fit. In the majority, you're going to want your subcontractors to just do the work and to produce the goods. Yeah. So they are, again, labor-only subcontractors and genuinely in work for themselves. Now, an interesting one here is if we go back to the bricklayer example, and the bricklayer builds that wall for you and makes an absolute mess of that wall. So the wall's got to be taken down and it's got to be rebuilt. And whilst the wall's being taken out, some of those bricks are now not fit for purpose. Is that self-employed contractor responsible for paying for the bricks that they have damaged? Are they responsible for the time that it's going to cost them to put it right? Yeah. If you can say yes to those both elements, then you could argue that they're in a business for themselves. If at the end of the day you don't expect your self-employed worker to correct and actually put right the work, then you could argue that they're an employee. Another issue as well is what happens if you thought that first fixing of the house was going to take, let's hazard a guess, 30 hours for the package that they were subcontracted to do. And that self-employed worker comes to you and says, it's actually taken me 30 hours, not 20. Can you pay me for the other 10? That's an interesting one, isn't it? Yeah. Because you'd argue that if you had a contract for services, or for each contract of services, you'd have been explicit with regard to how many hours are required. So an employment tribunal would want to say, if you did pay them that extra 10 hours, why did you pay them that 10 hours? Was it your fault as the company that you prevented them from working at the speed or the momentum of which you envisaged in the first instance? Or did you mess the contract up because actually the actual hours you set aside wasn't realistic? Or they were slow, or they couldn't be bothered, but you still decided to pay them the extra 10 hours. So again, you can understand these are the sort of tough questions that will be asked. I did a tribunal case with one of our members many years ago in a case in Dundee, and it was quite an interesting one because this was the argument argued, and I will, from first-hand experience, the judge does not give you an easy time, or the bench does not give you an easy time with regards to trying to understand if you've applied these tests as an employer. Okay, so the last slide that I'm going to, before I hand across to Ian, the last key consideration, and again it probably crystallizes what Gillian said, is irrespective of how you describe someone, whether in written documentation or verbally, does not necessarily dictate their true employment status. It is necessary to look behind the label.